Thank you, Mr. President. I didn't know where I was on the line. I've been watching a number of the provisions. I actually tried to follow the conference committee. I'm pretty proud of myself. I've never actually listened to what's this called, Judiciary, Public Safety, whatever, conference committee, and I found it really interesting. I learned a lot about no-knock warrants and that I didn't know, but there were a few provisions I was concerned about, and I was kind of relieved that they wouldn't be coming back because they hadn't passed the floor of the Senate yet, and we hadn't had a chance to debate them. And there's, unfortunately, two of those items are in this bill that I think should have been just left happily on the House side and not taken up, and why I'm urging members to please, for heaven's sakes, pass this bill back to conference. And Mr. President, maybe they're not as bad as I think, so I might ask Senator Latz to yield in a minute, but just I'll describe the first one. It's on page 69.16. It's called Concealing Birth. And so it seems to me like it's a really bad idea to allow a person who's concealed the birth of a child who's born under the age of 2 years from a consequence. And the law writers before this agreed with me. It was worth 5 years if you were going to conceal the death of a 1.5-year-old. And so I don't know how much that protection protected anybody, but it seemed like it was a good law to keep. And now it's a misdemeanor. And so before I even suggest that this should go back to conference, would Senator Latz yield for a question, Mr. President? Oh, would Senator Latz yield for a question?
Senator Latz, will you yield? He will yield. Senator Abeler.
Senator Latz, as I read this section 20 on page 69, it looks like just a really bad idea. Can you tell me why you think it's a good idea and why you should keep it and not take it back to conference?
Senator Latz, when you're ready.
You see this, John?
Senator Abeler, he just needs to get a copy of the bill.
Mr. President, I have time, and I'm enjoying the privilege to stand here in this august chamber. Thank you.
I think he might be ready. Senator Latz, are you ready?
Mr. President and Senator Abeler, Senator McQuaid is most familiar with this particular provision. I'd ask if Senator Abeler would allow Senator McQuaid to respond to the specific question.
Senator Abeler.
Thank you, Mr. President. Would Senator McQuaid yield for the same question? Would Senator McQuaid yield for the same question, or should I restate
She will yield. And Senator McQuaid, did you hear the question? All right. If you'll repeat the question to Senator Abeler.
Well, thank you, Mr. President. And on page 69, section 20, it talks about we're changing if somebody conceals the birth of a child who dies for some reason, actually any reason, under the age of 2. It used to be a 5-year penalty, and now it's simply a misdemeanor. And so, Senator McQuaid, can you tell me why that makes any sense at all?
Senator McQuaid.
Thank you, Mr. President. The answer to the question, Senator Abeler, on 69.19, it is still a misdemeanor.
Senator Abeler.
Well, Mr. President, I am not an expert on the law. Can you tell me, would she yield again?
Senator McQuaid, will you yield? She will yield. Senator Abeler.
And so I don't know if misdemeanors get 5-year penalties or not, but it seems that that's a pretty big one. Can you tell me why it should not be punished by imprisonment for not more than 5 years? And now it's okay. It's only a misdemeanor, which I think is usually like a fine or something. And this is a 5-year go-to-prison defense, which, just to help understand the context, it seems to me, Mr. President, if you have a 1.5-year-old child and they die for some reason, and then you attempt to hide the body, and that I think 5 years is too little for them to go to prison, particularly if they had a hand in that. And so it seems that that would just be a change that is not a casual one, to go from 5 years in prison to a misdemeanor. And so I'm curious if Senator May Quaid will yield.
Senator May Quaid to the question.
And so if she would tell me why on earth that makes any sense.
Okay, so let me recognize, is that okay? All right. Senator May Quaid.
Thank you, Mr. President. Mr. President, the answer to the question requires an actual reading of the bill. So in the original section that is still preserved, it is still a misdemeanor to attempt to conceal the body of a child if it dies after it's born. What is struck is the 5-year, not more than 5-year imprisonment if somebody attempts to conceal a stillbirth more than once. And so we have preserved the misdemeanor crime that was originally in statute and clarified the language, I should say, to ensure that if a child dies 1-2 years after it's born and a person attempts to conceal that body, it is still a misdemeanor crime. What is struck here was the burial of stillbirth or children who die in utero, because it was infringing upon people who were grieving and mourning and choosing how to grieve and mourn in their own practices.
Senator Abeler.
Mr. President, I'm not persuaded this shouldn't go back to conference. We're not talking, this is stillbirths or children up to the age of 2. And so I don't know anybody who defines, Mr. President, on line 69.20, it says, or the death of any issue under the age of 2 years. So, would Senator Lance yield, and please tell me what that means then, if it's not a person, the issue is, I think, a person. So, help me out here, please. Somebody, Senator Lance, would he yield?
Senator Lance will yield. Senator Lance will yield.
Mr. President, Senator Abeler, the language that is struck as I read it deals with second offenses, and it deals with stillbirths, and it deals with attempting to conceal the death of any issue under the age of 2 years. So we're not talking about killing anything. We're talking about efforts to conceal a birth or to conceal a death. And this is in response, in part, to a very, very old federal decision that dealt with abortion-related matters as well. So you'll see the additional language in there that exempts disposition of remains resulting from an abortion or miscarriage. But the language that is struck here, so it would decriminalize those who are disposing of the remains following an abortion or miscarriage, and it would leave as a misdemeanor penalty for either stillbirth or a child dying under the age of 2 for any attempt to conceal that. So it eliminates the enhanced penalty for what might be called repeat offenses.
Senator Abeler.
Mr. President, I'm less comfortable than I was before. And I'm uncomfortable with the intent to obfuscate this as simply an abortion or stillbirth issue. And I didn't intend to make this an abortion debate today. And I understand stillbirths. We've had 3 of those ourselves, and they're horrible. And so, but that's an entirely different circumstance than a child under the age of 2 who happens to have died. And I just don't understand how the 2 people who seem to know what this says think it's no big deal that we shouldn't have an enhanced penalty for concealing the death of a child under the age of 2. I think that's a big deal. And Senator May Quaid would like to offer a thought. Mr. President, I'd be happy to have her offer whatever thought she's standing to express.
Senator Abeler, are you asking Senator May Quaid to yield for a question?
I'd like to ask her to yield and have her say what she's intending to say. I would appreciate the thoughts.
Senator May Quaid, you will yield. Senator May Quaid to the question.
Thank you, Mr. President. I think it's really important for us to distinguish between the issue that Senator Abeler is talking about and what this statute was attempting to do. The statute as written would criminalize people who experience miscarriage or have an abortion, and also brought in it also brought in different crimes that exist in different parts of statutes. So what we have done here is we've preserved the intent of the statute by striking the language that made it unclear and or could be interpreted to criminalize people who experience miscarriage or abortion. And so that is why we have preserved the misdemeanor penalty for attempting to conceal the birth, attempting to conceal the body of a child who was born and then died. So that is still preserved as a misdemeanor. What we have struck is the language that could be used to criminalize people who experience miscarriage or have an abortion. It is still a crime to conceal the death of a child who has been born, and obviously the body concealment is dealt with here, but in other statutes that is also dealt with as well, and is obviously still illegal to cause the death of a child, and that is contained in other statutes as well. So this is clarifying this chapter of law and removing the things that might criminalize people who experience miscarriage or have an abortion.
Senator Abeler, it looks like Senator Latz was going to do a follow-up, but you have the floor, so I have to give it back to you, and you decide if you want him to say anything. Senator Abeler.
Mr. President, would Senator Latz yield to say whatever it is he wanted to say?
Senator Latz, you will yield? He will yield. Senator Latz.
Mr. President, Senator Abeler, as you can see from the language that's in the bill that is being struck, it was very poorly written by the legislature back in the 1930s or the 1890s, whenever that language was first written. So there was good reason just to clear some of that really confusing language out of the statute. But more importantly, I want to point you to Section 609.502, which is still existing law, is not addressed in our bill at all, which makes it a gross misdemeanor to conceal evidence or interfere with the body or scene of death with intent to conceal the body or conceal evidence. Makes that a gross misdemeanor. And then actually to conceal the body is a 3-year, $5,000 felony. So without regard to age, attempting to conceal anybody is still a felony under 609.502. So what you have in front of you is a statute that was poorly worded, had some inconsistent or conflicting language, and had become a basis for causing problems with regard to the disposition of the results of an abortion or miscarriage. So that's the only thing that's there. The bottom line is it's still a felony if you attempt to conceal a body following a death at any age.
Senator Abeler.
Thank you, Mr. President. I wish we could have had a chance to discuss this on the floor going out so we could have cleaned up this language. Because, Mr. President, this needs to go back to conference, because what the sentence now says on 6917 is that any person who attempts to conceal the birth of a child of any disposition of its dead body when the child died after its birth shall be guilty of a misdemeanor. Mr. President, child goes up to age 17. We've now created conflicting law, which is only a misdemeanor to conceal the birth of a 17-year-old for any reason whatsoever. And I think in our haste to protect the people, you read the plain language, Mr. President, that's what it says. If you're concealing the birth when the child died after its birth, and it's indefinite as to time. And so in our zeal to make sure we have, well, frankly, abortion from all the way from conception to like a day before, we would need to protect this piece of language, and it's written badly. I have no problem with when people have a stillbirth at home and want to have their own private ceremony, as we did, Mr. President, and there was no one who grieved more as our family at that time. And it was very meaningful, and we didn't commit a crime, and it shouldn't have been a crime. And I don't think disposing of an abortion remains of a baby in a way that is humane should be a crime either. But this does not make sense. Mr. President, I'll move on to the next section. And I don't have that many, but you have a law that doesn't make sense. It's a gross misdemeanor or it's a misdemeanor. It used to be 5 years, now it's just probably a $300 fine. So go ahead and have your child disappear when they're 17, and we're totally cool. Or when they're 1. And Mr. President, there is nothing more heinous than people who are abusing their children and they throw them into a dumpster. This is what is now a misdemeanor. When the way this is written, and in their haste to get this all done and have nobody on the other side and just do whatever made sense to them with no advice from the balancing opinions of our side to their side, it always gets better. And now this is going to become a law because I will gamble that nobody on the other side is going to have the courage to send this back to fix it. And I don't know that, but I hope they do. Mr. President, I have something else that should go back and get fixed. I don't understand it. On page 438, subdivision 44, Senator Matthews mentioned it. And so for some reason, it was on 438.20, and for some reason back when, we thought it made sense to point out that we are not comfortable with adults having physical or sexual attachments to a child. And there was a prohibition there, and it said it's not even sexual orientation. It's just, we're just not going to, this is not something we're going to allow for. And so somebody way before my time said, you know, I appreciate sexual orientation. I've learned a lot about it. And some people, you know, this bill is full of that topic. And I appreciate the definitions that were there. They made sense to me. They've been updated, and I'm not even here to argue about those. But, Mr. President, when a grown person finds themselves involved with a 12-year-old person of the same or opposite sex, most of us find that to be offensive. And so I was comforted that at least that wasn't defined as sexual orientation. And I was further at least encouraged that the other body decided to say, no, that's not a protected class. But, Mr. President, in this state, sexual orientation is a protected class. And this act is no longer defined as being not something that's a sexual orientation. And so would Senator Latz yield for a question, please?
Senator Latz, will you yield? He will yield. Senator Abeler.
Thank you. So why did you have to get rid of this sentence, which made it so clear to us that it's not part of the protected sexual orientation? And how does having it be gone offer any protection from this in terms of people saying they're a protected class?
Senator Latz.
Mr. President and members, the definition of sexual orientation in here has to do with sexual identity or gender, is not a function of age. So the language relating to age was simply stricken because that's not within a definition of sexual orientation. It remains a crime in Minnesota to act on any impulses that cause sexual contact or anything like that with any other person against their will, but particularly if they are underage. But the definition of sexual orientation is a whole different question, which has nothing to do with the age of the other person.
Senator Abeler.
Mr. President, there's a reason that we customarily have one side pass a bill, another side pass a bill, and they look at the same bills and they get to talk about it. The other body spent a good deal of time talking about this. I'm not convinced that this is nothing. This doesn't talk about consensual or non-consensual. There is no end of stories about 19-year-old boys who fell in love with a 17-year-old girl or a 16-year-old girl, and they wound up getting married eventually, but the fellow was convicted of a crime. And it was not unconsensual. It was actually, they were both pretty glad about it. But nobody said that was a function of their... This changes that, Mr. President. I asked a judge about this. I asked a couple of judges about this, and they go like, this is not nothing. And the day is going to come, Mr. President, because this is here, which should go back to conference and be gotten rid of. Just leave it the way that it is. Define the rest of the definitions the way you got them. Leave this little tiny protection in there so that there's not a legislative action to decide that this is something okay. In Anoka, there was a fellow named Jefferson Fitek who was the head of a group at Anoka Middle School, the GLAD group. And it turns out that he was involved in such a topic as this. And in fact, with 5 young men. And so society's reaction to that was that he's in prison for 30 years. And we all believe, I believe, that that's a good place to put someone like that. This is moving the idea toward a person's going to be found with such an this adult with a child, and they're having an emotional or a sexual interaction. And because we're doing this, it is now potentially arguable that it's a matter of their sexual orientation, which is a protected class. This should have been on the floor to be discussed with everybody getting to talk about it. It should not just have come back randomly like this. And but Mr. President, I saved the best for last, or the worst for last. And on the repealer section, it's 453.2. It repeals section 360A.20. And I'm going to ask Senator Latz to yield and ask him why on earth you would want to do this. Section 363A.20 has to do with exemptions based upon employment. And this
so can I ask Senator Latz if you would yield, and then you can ask the question?
Oh, yeah. Oh, is he going to yield? Yeah, you can ask.
Yeah, Senator Latz, will you yield?
Mr. President, I will yield, but if Senator Abeler could point out the specific page and line number he's referring to, that would be helpful to follow his question.
Senator Abeler.
Well, thanks. And Senator Latz, you might want to look up 363A.20 because that's what's being repealed in the bill. Because the repealer only just references that you're repealing that section. So 368.20 is the focus of my final area of concern. I have many more, but I'm just kind of giving you the most horrible highlights. This section, what you're repealing, is an exemption based upon employment. And this says pretty much that a church can decide that if you're not of the faith of that church, or don't have the tenets of that church, you don't have to hire them. And this is an exemption from some of the civil rights ideas. But Senator Latz, I'm going to ask you to tell me how this affects a church now. So subdivision 2, it says that the provisions of 363A.08, which is discriminatory practices related to unfair employment practice, things you can't do. You can't discriminate based upon religion, national origin, sex, marital status, etc. But that's repealed here. The exemption from that is repealed, and so a religious institution, church, in particular, is my concern. The other fraternal organizations, whatever, they're on their own in this discussion. But how will this affect my church? And if the people have doctrine and they believe in Jesus, and some people don't believe in Jesus. Some people believe there's a mighty God who is watching over us and actually has a lot of standards we should live up to, and we should pay attention to that. And some do not. So, Mr. President, and Senator Latz, would you yield and describe for me? Did you think that this might affect a church when you repealed this?
Senator Latz, to the question when you're ready. Take your time when you're ready. Senator Latz.
Mr. President, I would again ask Senator Abeler to identify the page and line number in the conference committee report, because it's not, as I understand it, it's not all of 363A.20 that's being repealed. So I want to make sure I have the exact question in front of me before I can give him an answer.
Senator Abeler.
Well, thanks. And Mr. President, I hope I'm wrong, and maybe upon further review things are better. But it's page 453.2. And if I have to say never mind, I will be unproud enough to say that, and then I'll stand down. Thank you. Senator Latz is 453.2.
Senator Latz, did you hear the page number?
Mr. President, I appreciate the question.
Abeler.
Actually, we had it a little more carefully, and so the churches are fine. So thank you for that. That's not a good reason to send it back, but the other two reasons are, and so I won't delay any more. I'm frankly relieved that I was wrong. But on the other two parts, Mr. President, I just want to say, Senator Latz and others, there is a reason to include both sides. There's a reason not to work behind closed doors. There's a reason that we can make laws better, and you can even educate people like me who make a mistake about what they thought was included, but then when things are included, they can be made better. So, Senator Latz, please send these back and go fix these other parts. Thank you.